Yeah, I'm sorry for the changes back and forth in the schedule. We were going to have a vote at certain times, and then it's going to be later, then it was going to be earlier. And, something I'm finally learning about the Senate schedule after 48 years. But thank you all for being here, and we're just starting billions of people around the world, as we know, are inspired by art, music, film, photography, theater, books, and more. Art can make us laugh and cry, entertain us, reflect the human condition, can rouse us to take action against injustice, cause us to acknowledge our shared humanity. It can be powerful, beautiful, enlightening. Our founders anticipated the importance of rewarding artists for their hard work. The Constitution includes an intellectual property clause to make sure that artists and creators can benefit from that. We set the fundamental copyright rules of the road with the internet in the late 1990s, with the Digital Millennium Copyright Act. Then, a decade later, the Intellectual Property Enforcement Coordination. The years since, we've worked closely with the Copyright Office. I'm going to put most of my statement on the record because Senator Tillis and I may have to leave, well, we'll have to leave shortly for another vote, and I'll come back. But I will rely mostly on my questions when we do. But the collaboration we've had the last few years with Register Perlmutter really makes a difference to us, and I appreciate that. And we'll have more questions for you. Senator Tillis, I'm putting my whole statement on the record, and I yield to you.
Thank you, Mr. Chairman. I'll follow your lead because of all the logistical challenges. I want to thank you for holding the hearing, and I want to tell you I'm proud of our copyright system, and I'm also proud of the work that I've had the privilege of doing with you, Mr. Chairman. I think that we have to continue to work on copyright protections. We have to continue to recognize that it's a $1.3 trillion economic impact annually, and it employs nearly 7 million people. And I believe that the work that we've done in the past has been a great step, the CASE Act of 2020 being one example, the work you did before I came into the Senate, another example, and the work we intend to do in this committee. But in the interest of time, I think maybe we could get to the opening statement, and I will submit my full statement for the record. Thank you.
Sure. Well, you too. Thanks, Senator.
Thank you. Good afternoon, Chairman Leahy, Ranking Member Tillis, and members of the subcommittee. I'd like to begin by thanking Chairman Leahy for his decades of advocacy toward the constitutional mission of promoting the progress of science and useful arts. Mr. Chairman, you have been a champion of copyright throughout your career, and your role in shaping today's copyright system, as well as your steadfast support for the Copyright Office, are greatly appreciated. Since our last hearing before this subcommittee, the office has accomplished a lot. We began this year by issuing a new strategic plan aimed at making the copyright system more accessible and up to date. In June, we launched the groundbreaking Small Claims Tribunal established by the CASE Act. As of today, nearly 150 claims have been filed, and the Copyright Claims Board is moving efficiently to process them. It's still too early to know how heavy the caseload will turn out to be. But meanwhile, we're actively reaching out to the public with information about the existence and operations of this new tribunal. At the same time, the office has been busy responding to congressional inquiries. We completed studies on press publishers' rights, on state sovereign immunity, and on deferred examination. And we're now working on requests related to the best edition requirement for copyright deposits and the IP issues related to NFTs in collaboration with the Patent and Trademark Office. Two other ongoing projects relate to technical measures for identifying or protecting copyrighted works online. We've also engaged in extensive rulemaking. In addition to those setting up the CCB, as of early 2021, the office had issued all the regulations needed to implement the Music Modernization Act. We continue to exercise an oversight function as directed by Congress while conducting numerous outreach activities. And last October, we completed the 8th triennial Section 1201 rulemaking. The office is also prioritizing the enhanced use of data as part of our new strategic plan. We recently issued a report on women's participation in the copyright system, finding a gender gap in women authors' share of registrations, but one that has been shrinking. We released the underlying data set in bulk and are planning further research to identify other potentially underserved groups. This will help inform our outreach activities and also further the goal of broadening participation in the copyright system. On the operational side, the office registered over 400,000 claims to copyright for millions of works in fiscal 21. We have markedly improved processing times. The average for all copyright claims now stands at 3.6 months. And for fully electronic claims that don't require correspondence, the average is down to just over 1 month. And as of this August, we've eliminated the backup of physical deposits caused by the pandemic. With respect to recordation, in fiscal 21, the office recorded more than 11,000 documents containing titles of close to 1 million works. And a major milestone was reached last month with the opening of our online recordation pilot to the public, moving from the prior entirely paper-based system. Processing times online are now measured in weeks rather than months. And meanwhile, we've nearly finished consolidating deposit materials from several storage facilities into a single modern warehouse. This will enable faster location services, better tracking, and improved security. Modernization remains a top priority for the office. The planned Enterprise Copyright System, or ECS, will update and enhance all of our services, making them more efficient and easier to use. The online recordation system was the first major public release, and the Copyright Public Record System now offers an improved interface and advanced search functionality. Development of a new and improved registration system, which is the largest and most complex component, is well underway. And we're making a lot of progress in digitizing pre-1978 records and putting them online. Throughout all of this, public feedback has been vital, from pilot users and from focus groups, as well as from the library's recently established Copyright Public Modernization Committee. As the ECS becomes fully operational, we'll be seeking support for ongoing maintenance and improvement so that we can avoid repeated overhauling of outdated legacy systems. And finally, our operations would benefit from greater flexibility in our use of collected fees, with the authority to provide continued access to our services, continued services, in the event of a lapse in appropriations. So let me close by thanking the subcommittee for your support of the office's work to foster creativity and ensure a thriving copyright system.
Thank you very much. Again, I apologize for the schedule. I'm going to go vote. Senator Tillis?
Yeah, I think it'd be best maybe if we both vote, just recess briefly, and he'll probably beat me back. He's pretty fast in that chair.
Yeah.
But we'll be right back.
My bat chair, thank you.
hearing with the instructions from the chair. He will be here shortly. And thank you, Senator Blackburn, for joining. Senator Blackburn, do you intend to ask any questions?
I do have a few questions.
Well, I was just wondering if you want to go ahead and go, Chairman's let us start the committee again. He'll be here shortly, and I can defer. I'm going to be here for the duration of the committee hearing, so in interest of your time, if you would. I don't want to rush you, but...
And thank you, Mr. Chairman, and I want to say thank you so much to you for being here. One of the things that I wanted to talk with you about, of course, being from Tennessee, copyright is terribly important to us. As we like to say, 3 chords and the truth get you a long way when it comes to the music industry. And we've worked on things like the Music Modernization Act and tried to push forward some of those concepts that will strengthen copyright protections and also strengthen against infringements, which, as you know, has become really quite an issue. And I don't want you to comment on this case, but I do want you to walk through with me how you look at potential implications of a broad fair use standard. And I have filed an amicus in Andy Warhol Foundation versus Goldsmith, and that is currently before the Supreme Court. And of course, that really broad fair use standard is something that can be easily abused. So I'd love for you just to comment for a couple of minutes on that.
Thank you. The question, the Warhol case is the first time in a while that the Supreme Court has taken up the fair use issues outside the context of computer software. Sorry, do I need to repeat? No. It's going to be a very important case for the future of the fair use doctrine and for copyright. The Copyright Office worked with the Department of Justice and signed on to the government's brief in the case, which makes a number of important points, taking the side of the photographer. And the main points that we're concerned about are what does transformative use mean exactly? And how do you interpret it? So in particular, if transformative use is interpreted too broadly, it could undermine the existence of the derivative work right in copyright law, because if anything that changes the original is called transformative, then there is no more a separate derivative work right, which is defined to mean something that changes aspects of the original work. It's a new version of the original. So one issue is, how do you define what is transformative and avoid making it so broad that it covers all derivative works? And the other question is, what's the impact of a finding of transformative use in the fair use analysis? Because the Supreme Court has cautioned in the past that no one factor should control the entire fair use determination. So it's important that even if a use is found to be transformative, that the courts still go through all of the fair use factors and weigh all of the facts and circumstances of the case in light of those factors. So for all of those reasons, we're watching very carefully what the court will do. We urge the court to interpret transformative use not too broadly and to put it into its proper place in the full fair use analysis. And I think it's also very important in this case to bear in mind that it's a case involving a use of a photograph for the same purpose that the photographer herself is licensing it for use to illustrate a magazine article about the subject. And that's quite different than, for example, the use in an art exhibit in a museum. So those were some of the concerns we had and the reasons that we participated in the government's brief.
Yes. and we appreciate that. One quick thing before I turn it over to the chairman is it's still the case that the United States is one of only a few countries that does not recognize a performance right.
Yes, you're referring to the public performance rate for sound recordings.
Yes.
We have a narrow public performance rate for sound recordings, but not for broadcasting them over the air. And you're absolutely right. We are an outlier internationally in that respect. And it's anomalous as a matter of U.S. law as well, because broadcasters do pay for the use of musical works when they broadcast them, but they do not pay the performers and record producers for the use of the particular recording of the musical work.
And I'm hopeful we can soon change that.
And
Thank
we
you,
would
Ms.
support that.
Perlmutter. Thank you. Thank you, Mr. Chairman.
Thank you, and I thank Senator Tillis also for filling in for me. We've been different years with one of us in the majority and other years with others, and we've always tried to keep the thing running. And I apologize that these votes got a little bit different than we thought they would be. Follow up on the last, I have tried to provide musicians with over the Air Royalties. I tried that in 2009. I know in a small state like mine, a lot of the radio stations are still in rural areas. They didn't know they could go out of business if they pay a per song royalty. Now we have to make sure the copyright owners receive royalties. We're making those royalties palatable for small market radio stations. The American Music Fairness Act was well-intentioned, but doesn't address the concerns of small town radio stations and could force them out of the broadcast business. I'm not asking for an answer of how we fix that today, but I think we should continue work on that, because sometimes in small communities and in rural areas, the local radio station is one thing that keeps the people posted on what's going on, the news, everything else, but also they got to pay the bills to make it work. But I applaud you on your launch in June of the Copyright Claims Board. I've thought for a long time that's a way for creators to have an inexpensive way to protect themselves from intellectual property theft. And you know, in a digital age, there are more and more ways to steal intellectual property. The CCB will give the ordinary Americans a day in court without the cost or complexity of filing a typical lawsuit. I think the process you've set up seems very user-friendly. So if you can keep us posted on how it's going. I mean, how's it going so far? Have filers had complaints or concerns about filing?
No. It's going very, very well. In fact, we put together an electronic case management system for the CCB, hired the entire staff, put in place a large number of regulations necessary to govern all the operations, and then have been doing a lot of publicity and outreach to make sure people know about it. And all of that has been going smoothly. So far, the CCB...
Those kind of instructions are always available to the public.
Yes, in many different formats at this point. We've been engaging with the media. We have materials on our website. We had a website with Q&A about the forum, about the new tribunal, even before it started, and now we have a dedicated website for the tribunal as well. We're doing a lot of speeches and public events to make sure that we reach out as broadly as we can to make sure people are aware that this is now an opportunity for them. It has been going very smoothly. We are not aware of any particular problems at this point, and as of the beginning of this week, there were nearly 150 claims that had been filed in the approximately 2 months that the tribunal has been in operation.
That's more than I would have expected. That's very interesting.
Yeah, I mean, it's going to be interesting because it's very difficult to predict exactly how busy they will be. We don't know yet how many respondents will choose to participate or to opt out, and it's going to take a little bit of time to have more data because there's various periods built into the statute for claimants to serve the claim after it's approved as compliant by the CCB, and then another 60 days for respondents to respond or opt out. So in a few months, we should have a better sense of where it's going.
You and your office have worked with mine on the question of privacy issues. Your system publishes each party's city and state, but doesn't put personal information or names. Can you make sure that if this protection of privacy starts having problems, that you let us know?
Yes, absolutely. We are very focused on it, and we appreciate your office's interest in this. We do have in our general counsel's office a number of experienced privacy lawyers who are very familiar with the laws and the Library of Congress's rules about privacy, and we're focusing on it throughout the process.
Thank you. I'm going to have further questions with Senator Tillis.
I'll defer to Senator Padilla. I'm going to be here for the duration. Senator, thank you for being here.
Thank you.
I'll follow you.
Thank you, Senators. I'm actually going to be pretty brief. The main question I was going to raise has already been raised by Senator Blackburn. So just here to underscore, well, first of all, thank Senator Leahy for his years of work on the American Music Fairness Act. I heard your response, Registrar Perlmutter, about the need to fairly compensate both copyright owners and performers for broadcast of their content. And so I assume that's the position. We're looking forward to making the latest legislative effort in that regard in the very near future. And just because I cut the tail end of your remarks to make sure I take away clearly, the United States is an outlier, remains an outlier on this issue?
Yes, there are very few countries that don't provide a broadcasting right for sound recordings, at least a remuneration right. And because many of them provide this right only on a reciprocal basis, they are not paying American performers and record companies for the use of their recordings. And so we're leaving a lot of money on the table abroad that could be coming into the United States.
Okay. Well, thank you very much. Look forward to working with you on the issue, including your technical guidance if necessary. Thank you, Mr. Chair.
Senator Tillis?
Well, thanks again, Register. I think you've done a great job, and I appreciated the progress that was embodied in your opening comments. I think compressing the time, being more responsive, applying technology are all the things I like to hear and seldom do in other oversight hearings. So thank you for your work. I did want to talk to you about the letter last month that you sent to me in the office regarding deferred registration examinations. I know in there you said that you had heard the concerns of some of the proponents of DRE and that you were looking at maybe alternatives and I think alternative approaches, and you outlined some in your letter. Can you elaborate a little bit more on the alternative approaches and explain the nature, scope, and status of your review?
Certainly. Thank you, Senator. We are evaluating a number of options, as you indicated, and we're looking at the legal aspects and the technological aspects, and then what the practical impacts would be of each of them. But we're considering them very seriously. Now,
if you could also touch on, I want you to go through it, but also touch on which of these you can achieve through your current regulatory authorities and what may need additional congressional action.
yes, thank you. We don't currently see the statute as a barrier to any of the proposals that we're considering, but they do require some technological changes. So we're looking into that as we develop the new enterprise copyright system. That doesn't mean we will wait until that system is completed before we do anything, but a lot of what these would require would have to be part of that development. So in particular, we're looking at the possibility of a dynamic fee structure going forward where some fees might be lower than they are today and some higher, and also the possibility of subscription pricing options, which stakeholders have expressed interest in. We have to see how those can be accommodated from a technological perspective. We're also looking at increasing the maximum, the limit on the number of photographs that can be registered as part of one group application. So we're working with the library's chief information officer on how we can do that. We are also looking at the technology necessary for APIs to enable hardware and software and third-party organizations to achieve integration with our system. And then more immediately, in the coming fiscal year, we do plan to issue a notice of proposed rulemaking on a new group registration option for two-dimensional artwork. So we think a lot of those things respond to the concerns that were raised in the deferred examination study.
Can you talk a little bit more, or do you have any more specifics to provide on the way the fees would work or the fee structures?
We're beginning to look into that. So historically, the office has done a new fee study about every 5 years, and the last one was started in 2017, and the new fee structure went into place in 2020. So it's about time for us to start focusing on this. And as you know, we just hired our first chief economist in the office. So the chief economist is beginning by looking into what the demand side, doing some research on the demand side of what demand there is, what flexibilities there are, and what the price sensitivity of different kinds of registrants is, and then looking at also our costs in registering and recording different kinds of materials. So he's beginning with that study, and then once the study is complete, we will use it to inform a notice of public inquiry where we will get comments from the public on the policy issues involved in changing the fee structure. So I can't tell you now exactly what it will be, but we are starting the process.
All right. And what kind of timeline should we expect?
Our intent is to start the process in calendar year 2023.
Also in response to a letter that Senator Leahy, the chairman, and I sent back in June, you held a series of consultations this summer on technical measures and that identify or protect copyright works. Do you have any initial impressions from those work group discussions?
Yeah, they've been very helpful discussions and quite intensive. We had both plenary sessions and small group sessions of various kinds. And we're still analyzing the wealth of information we received. We also received something like 6,000 written comments, so there's a lot of material to go through. But I would say so far what is clear is that there was some convergence on the issues that were important to look at. And that included, first of all, and this is an issue we raised also in our Section 512 report a couple of years ago, that there is a wide variety of contexts in which technical measures are used and a wide variety of purposes for which they're used. Second, there was a lot of focus on the importance of being able to obtain quality metadata for technologies that allow identification and attribution of content. A third issue, the impact of the differential impact of using either automation or human review for some of these processes. And then a lot of interest in having the government, and in particular the Copyright Office, act as a convener to bring people together. So what we're doing now is drilling down into those issues a bit, and we will be identifying for you what are the areas of consensus and the areas of divergence on those topics. And we think that will be a useful exercise.
Yeah, just then, Mr. Chair, if I may, I was going to ask you about areas of consensus, but one, do you feel like that the stakeholder group meetings were well represented across the spectrum. And 2, is there any particular area? Consensus is great, particularly any areas that are pointing to a trend that we may have some more stakeholder work to do. And then finally, when should we expect a written work product out of it?
We had very good participation in the sessions, very broad representation of different interests. In terms of consensus arising, as there is consensus on what the issues are and the value of the government convening, but as to the specifics of how those issues should be resolved.
Consensus on problems, not on solutions?
Probably, although we are still engaging in that analysis. So we're trying to pull out whatever consensus on ways forward we can find, and we will be able to give you more information on that. Our goal is to send over a report by the end of the year, so it will be fairly soon.
Okay, thank you. Thank you, Mr. Chair.
Thank you. And let me go to another area. Last year, Senator Tillis and I asked you to identify and encourage the use of technical measures like fingerprinting that might protect creators' work online. The DMCA intended to make some technical measures mandatory, but in more than 35 years, no court has held that any technical measures mandatory for any platform. So I thank you for undertaking the work of conducting feedback sessions on the existing opportunities, the use of mechanical or technical measures. You know, to try to balance the competing interests among stakeholders, as both Senator Tillis and I have said, often amounts to a pretty complex technological problems, but many other agencies, Patent Office, Department of Energy, have chief technology officers. Would the Copyright Office benefit from having a chief technology office?
We've been thinking about that question and are aware that there's been discussion of that in this subcommittee. We currently work very closely with the Library of Congress's Chief Information Officer and her staff, and of course that function has been centralized in the Library of Congress, and especially we're working very intensively in partnership with them on the modernization initiative and the enterprise copyright system. And we've also developed and brought in considerable in-house experience and expertise in the Copyright Office itself, working on many of these issues. And so far, that combination of the library's expertise in OCIO and our expertise has been sufficient to address our current needs for analyzing technology. And of course, we do a lot of consultations with stakeholders also about these technological issues. But, you know, it is true that technology continues to grow in importance and affect everything we do. And we are taking on more responsibilities and more roles, in large part at the request or mandate of Congress. And so I will say that additional expertise could always be useful. There's no question that the technology issues are not going away, and they will become even more important over time.
I know everybody has questions on royalties, well-funded publishers, platforms tentatively agreed to keep royalties for songwriters frozen at the same rate, 9.1 cents per song. That's been what it's been, I think, for 15 or 16 years. The board proposed a larger one. I think of the one dedicated songwriter who wanted that to be changed, drove at his own expense from his home in Florida to D.C. on numerous occasions, fully participated in the proceedings. Are there steps that could make the Copyright Royalty Board more accessible to writers who don't have the time for the money or the ability to fully participate in discovery, motions, and the entire proceedings.
Well, we strongly support the importance of those who are affected by these settlements being able to have appropriate input to the decision-making of the CRB. The way the statute is currently written, there is an opportunity for non-participants to submit comments but not to object to the settlements. And we know that there have been some proposals made for how that could be, how the input could be made more valuable, how the comments could be amplified in different ways, and we are looking at those proposals. At the end of the day, though, it is the CRB that has to make determinations about its own processes and rules, so we would want to consult with them about any such proposal.
Okay, well, I think we'll probably keep in touch on that one. And the Biden administration recently issued guidance requiring that all federally funded research be available to the American public at no cost, which I supported. And I would support it in any administration. We spend about $80 billion a year on research that was often held by commercial publishers and scientific societies, placed behind paywalls, and telling the American taxpayers who paid for the thing in the first place, if you want this, you got to pay twice. How do you see the copyright landscape changing when it comes to research material?
Well, as to the particular new policy just announced by OSTP, we were not consulted on it before it was issued, so we also just saw it when it came out. I know the existing policy has built into it the idea of a 12-month embargo before the content of the publications are made available for free to the public, and that was put into place as an attempt to balance the interest in getting all of the material completely accessible to the public as soon as possible, with making sure that the publishers could recoup their costs in developing and editing and publishing the articles that report on the results of the research. My concern would be that not having any period of embargo, but immediately having everything be available for free to the public could undermine the incentives for publishers to make the investments that are required to produce those articles and to go through the editorial and peer review process that they require.
Okay, well, let's, you and I and our staffs continue discussions with that. I know there's a balancing effect here. I also worry when we paid for it, when the taxpayers paid for it, how we get it out to people. But Tom, do you have any further?
Yeah, just real quick, it was a follow-up to the last question. And it had more to do with, what are your thoughts on the need for any sort of legislative action to empower the Copyright Office with respect to identifying STMs under Section 512?
So clearly, the DMCA was enacted in 1998, and no STMs have been identified to date. If that section of the DMCA is to be made a reality, to have an effect, having some sort of structure and some sort of rulemaking structure seems like it would be needed. The question is, in my mind, I have some concern over what entity should perform that role if Congress were to decide that such a rulemaking is necessary. I mean, it is true that the statute has been in place for 24 years now. Yes, so it's past its majority, shall we say, and it has functioned without any STMs having been identified. So one question is the extent to which that's still a necessary component of the balance. That's one issue. To the extent it is, some sort of rulemaking is probably a good way forward. Now, the concern that I was alluding to is that the Copyright Office doesn't have expertise in technology and in standard setting. And we are also acutely aware of the resources that are required to conduct a major rulemaking of this kind. And I will say the 1201 rulemaking, which we've now become very adept at, and we've refined the processes to make it much more efficient than it used to be for everyone, for stakeholders as well as for the office. That takes up a huge amount of time and effort by our relatively small staff. So those are my concerns as I look at the possibility of that structure.
Okay, well, thank you, Mr. Chair. I've got several other questions I'll submit for the record. And Registrar, I look forward to working with you as we try to move with the Smart Copyright Act of 2022. I get great reports from my staff on the work that you're doing and the work of your staff. So thank you for your continued cooperation. Thank you, Mr. Chair.
Well, and I would agree with Senator Tillerson that we deal with some parts of the government where we have equal concerns. Yours is not one of them. I hear a lot of compliments what you're doing from both Republicans and Democrats, and that makes me happy that government is actually working. So thank you. And we'll keep the record open for a few days for any questions, and I appreciate you being here.